we're going to get started. If we can, if I can call the meeting to order. I believe my first order of business is to ask if there are any public speakers. Hearing none, we will move on. Can I have a motion for the approval of minutes, please?
Second.
In favor?
Aye.
Okay, thank you. I've been working with Jim and Lamont to try to ensure that we have an orderly way through this. I think there are a number of things that are well worth discussing within this book. I assume everybody's been able to go through the papers, but I think Lamont has helpfully created a PowerPoint to give us some structure to our discussion. This is not intended to limit the board discussion in any way, but I thought would be perhaps easier than a free-for-all discussion that might otherwise take place. And I know there are items within here that are somewhat procedural and factual in terms of updating people. There are also items within here that we're going to go through that represent significant issues to us, and we should be spending whatever time we want to spend to be able to go through that. So that would be the intent of how we were seeking to do that. So if that makes sense, I'll turn it to you, and
Okay.
we can go forth.
Okay. The first item on the agenda is the approval of the 2010 committee work plan. We have not made any changes to it. It basically reflects the same plan as we had laid out for this year, and we recommend that we adopt that going forward for 2010.
Motion made. Second.
In favor?
Aye.
Okay. Thank you.
Okay. Item 2 on the agenda is the revisions and hopefully approval of the MTA Code of Ethics and the Board Member Code of Ethics, and a quick review of MTA Whistleblower Protection, which is encompassed within the MTA All Agency Code of Ethics. What you have in front of you actually is 3 things for each code. We've provided you with a summary, which is on page 9 for the All Agency Code, and page... Okay, I could have stopped talking if that's what you wanted.
You keep talking.
Okay. The summaries are contained on page 9 and page 91. 91 is for the board, 9 is the All Agency Code, but I'll walk you through that very quickly. As you can okay. All right. Basically, the changes that we are making are for purposes of clarity and consistency with new laws that were passed and new regulations that were put forth by the Commission on Public Integrity. Again, the changes are contained within that summary document. Next slide. On the next slide, you'll see just some highlights. One of the things that we changed relates to gifts. Prior to this change, we had established what we call a benchmark of $10 for what we call items of nominal value, which would not trigger a violation of our gift rules. The Commission has done away with the ability to put a dollar amount on what would not constitute nominal value. Instead, they go to a concept of what would be considered an item of insignificant value. And literally the definition of what would be an item of insignificant value: a cup of coffee, a regular cup of coffee, soda. No, literally a regular cup of coffee. They have made distinctions between, I'm not going to use Starbucks name, but higher end coffees versus your regular coffee, a soft drink, water. So it really has lowered it well below the $10 benchmark that we had established. But again, we will communicate that to employees so they know what that new standard is. We also included a clarification regarding fundraising. That MTA employees should not use MTA's name, their official title or position for private fundraising activities. We have always interpreted the code to have that restriction in place. We just provided a clarification for that.
Does that extend to the board as well?
This is in the employees code. This is the employees code.
Should that provision extend to the board as well, or does it? Does it not?
I haven't had that issue come up, frankly, with the board. Usually this comes up with charitable organizations asking our agency presidents to sit on honorary committees for the purposes, frankly, of enticing people to participate in the event. And we've always took the position that MTA's name and employees' titles can't be used in order to, get our vendors to, support their events. I have not had any questions from the board regarding that, but it is something, if you want, that we could consider.
The same principle in terms of a public office, whether it's a board membership or position as an officer, applies in terms of use of that office for private fundraising.
Then it should probably be spelled out in the board section as well.
It seems to me to be appropriate if it's not already in there.
No, it's not.
The principle is in there. It may not be spelled out with a particular as to fundraising.
Right.
We'll take that away. Thank you.
Yeah, will do. Okay. New to the code is the political affiliation and political contribution section. It adds a prohibition which is contained in the Public Employee Ethics Reform Act regarding inquiring into political affiliation or political contributions, most in the area of procurement and employee relation matters. Bottom line is you can't ask anybody their political affiliation or whether they've contributed to a political campaign when you're looking to promote someone or looking for a vendor to contract with. Okay. Okay. In terms of what the Jim, if I could just deviate for 1 second from the slide. Again, the summary for what the changes are that we made to the board code is on page 91, so you can see what those are. And the only other change I would want to mention here, which is not on the slide, is the whistleblower protection. That is contained within our Code of Ethics, and we have, again, clarified it to make sure that it was understood that whistleblower protection extends to our employees beyond violations of the code, but also includes laws, rules, and regulations as well. Policy procedure. Oh, I'm sorry. I'm sorry, Jay. I shifted. I'm sorry, Jay. I shifted on you. Sorry. 91 is the summary for the board members' code. So there would have been asked some questions about that. That's where you can find that at.
Right. I got that.
Okay.
The whistleblower, you went back to, where are you on whistleblower? I'm sorry.
Whistleblower's back on 9.
Back to 9.
I went back to 9.
That's fine.
Okay. Again, the way it was worded previously, it could be read to only apply to violations of the Code of Ethics. So what we did was we made sure that it was clear that the whistleblower protection extended beyond just code violations, but included policies, procedures, laws, etc. We just, again, this was a matter of clarity. We've always interpreted it that way, but it was just to make sure that it was clear. Yes. 9 is the summary.
I think the place where, Lamont, if I can speak perhaps for others,
Mm-hmm.
I'm a little bit lost by, are you going through the slides and using the slides to take us through what your points are, or are you working off something else?
Okay.
I thought we were
I'm sorry.
on the slides, so I'm a little confused. I'm sorry.
Yeah, no, please let me clarify. What wasn't contained in the slides, and I just realized when I looked up at the slides, was the whistleblower, which needed to be covered today as well. Because if you look at item number 2, it includes revisions to the Code of Ethics and review of MTA whistleblower protection. And there is not a slide for that, but I wanted to make sure that we did, in fact, cover that agenda item.
Why is that different from the Code of Ethics itself? Because it's in the Code of Ethics.
Yes, our whistleblower protection is incorporated within our Code of Ethics. It is, in fact, Section 106. That is correct.
There's nothing else.
That is it. That is what we have. We do not have a separate policy. It is incorporated within our Code of Ethics.
If I may, Lamont, am I correct in saying, I believe the reason why Lamont is drawing separate attention to the whistleblower policies is that under the public authorities law, as a public authority, we're supposed to have adopted a code of ethics, which we've done, obviously, and now we're proposing to update and revise it, and we're also supposed to have reviewed periodically whistleblower policy. So that's why he made separate mention of it, I
Right,
believe, correct?
to make sure that we, in fact, covered what we needed to cover, yes.
So, okay, so before we, again, if I'm with you right now, pages 2 and 3, plus your comments about the whistleblower are the points that you want to make on the all-agency and board member codes of ethics.
That is correct. That is correct.
So, discussion. Is there any discussion before we move to a motion in terms of a recommendation to adopt?
I need to look at section 106 because with the whistleblower and it's saying here it was expanded, I need to see what's in there with the first part of it to see, to get a better feel of it because I'm really not.
It was in the book that you were sent.
Right.
So,
Okay.
so is there a?
I didn't see that one. That's why I'm asking for it again. Because
Yeah.
Okay. So, what page should we go to, Lamont?
Go to page 56. There's a red line version which shows what it looked like before and then after the change. The underlined items are what we added. Yeah.
Right.
What we thought was happening.
Right. Again, it's really a matter of providing clarity to the code. We've always interpreted it that way.
that's what I was looking for.
Okay. Terrific.
I'm good. That's what I was looking
So then, can I ask for a motion to recommend, or for a recommendation to adopt the all agency and board members code of ethics?
for. Put a motion to second.
In favor? Okay. Terrific.
Okay, that brings us, next slide, to the portion of the agenda that's on the governance, review of the governance principles, which has two components. We have existing governance guidelines, which we have reviewed as required by the Public Authorities Law, which requires board members periodically to review the governance guidelines. And we have recommended changes to the governance guidelines based upon, as you'll all remember, in May, substantial legislation concerning the MTA was passed that did a number of things, but among those things is it adopted governance changes in how we work as a public authority. So I have reviewed, as has compliance, the governance guidelines that existed in the attempt to now conform those governance guidelines to the statutory changes, because obviously the statute governs our governance structure ultimately. In addition, and this is separate, and we'll get to this a bit later, Jay and board members have expressed interest in considering adoption of governance guidelines with respect to labor relations matters. And MTA Legal, working in conjunction with the Director of Labor Relations, accordingly has drafted for your consideration, the Governance Committee's consideration of proposed guidelines for governance of labor matters. The first thing, the revised governance guidelines of the existing ones, appear in your book on page 126, but we've handed out a black line version because I noticed that our copying on the black line version that you have, not on the other version, was at a few points difficult to read. So we handed out a black line copy to each of you in case you're having trouble with that. And let me take...
There's nothing new in that, then,
Excuse
basically.
me?
Nothing different in this.
No, I think,
In the handout.
other than I think the black line in the book with respect to the
Just more readable.
committee section was hard to read and
Right.
seemed to have somehow been wrong, but there are no changes there, other than adding the word corporate to governance committee. So with respect to that document, let me just take a moment to run over what this is about. Can I have the next slide? The basic mission here was to update the guidelines to reflect the statutory changes in the May legislation. As you know, the biggest change of all in terms of governance that the legislation passed in May was it made the chairman the chief executive officer of the MTA, and it appoints the chairman with a fixed term, and following up on the Ravitch Commission recommendation that had been made in the prior December. So that's a significant change, and obviously requires us to change language in the governance guidelines that previously reflected a different governance structure, one that we no longer have. So in a sense, what we've gone back to is a version of the governance structure that we had back before 2005. History goes in cycles, perhaps, but in 2005, you'll recall the legislature passed the Public Authority Accountability Act. That said, you've got to have separation of executive director as CEO and the board and the chair. And now this legislation in May said, no, that's the wrong model, following up on the Ravitch Commission recommendation, and said the chair shall be the CEO. So that's the most significant change. And the legislation is very clear in giving the CEO the power to appoint officers and employees in accordance with his judgment as he believes is necessary to discharge the executive and administrative functions of the MTA. So that's what the principal changes in the governance guidelines that I've made or proposed to be made to conform to the statute are. Next slide.
Unfortunately, the law did not say that you had to tell the prospective chairman about the financial issues that were facing. It seemed to be part of the law.
That's what you're right, because I'm looking at it and I'm saying, we're reading that the government, the governors of state and everybody else is not giving us X, Y, and Z, and we're short 200 million plus this million plus that, and it's almost like you want us to pass policy and procedure or implement this, but they're not doing what they're supposed to do. So they're really putting the guy on the hook. Sorry, you're the one on the hook.
We can talk about it in the third person. Don't worry about it.
They're really putting them on the hook with that. So do we really have to follow what they want us to do now that they're reneging on what
My comment is it was a quip. We all understand the circumstances. Let's not take it as any more than that. There is a need to follow the law. Let's start with that as a first principle. Go ahead, Jim.
Okay, so just to highlight, the statute did a few other things. I think you're familiar with these changes. It made the executive director position an optional one. As you know, it used to be a position that was a mandatory position and that was appointed by the board upon the recommendation of the chair. That's no longer the case under the new law. The CEO compensation is determined by the board, and to prevent any conflict there, the statute has expressed that that's without participation of the chair. So we've modified the governance guidelines to make that clear, to reflect that that's something that the board does without the chair's involvement. And the statute that was passed in May is very clear about the chair CEO's role. Is not just that for the MTA, but he's ex officio the chair and chief executive officer of each of our two affiliates, the TBTA and New York City Transit Authority, as well as the chair and chief executive officer of each of the subsidiaries. So those are the principal changes that I've sought to update the governance guidelines to reflect. If you refer to the handout, you'll see a marked up version of it, and I'd be happy to address any questions about the proposed revisions at this point. There are some changes that don't relate to legislation, but that are there for clarity or because it seemed like a good idea to have them there.
I think Doreen was I'm sorry, if I can. Doreen?
This isn't a question about revisions to language, but it's a question about the functions of the MTA board and maybe the wording. Maybe I'm being too much of a nitpicker on the wording, but in A, I'm talking about page 123, 2, little a in the whole, providing counsel and oversight in the evaluation, development, and compensation of senior management. We do more than provide oversight in determining J salary.
Right.
And there's that next sentence.
Right. The next
that
sentence is very specific about the CEO.
How far down the food chain is the board supposed to go in determining compensation for senior management?
Under the law, I think that you have authority to set the compensation for the CEO, and then separately, I believe, for the IG, and that's it. And that's not actually a change. That's the way it was before. The executive director determined the compensation for the other employees in the organization.
And are we supposed to be providing counsel and oversight on the determination of those salaries?
You're certainly entitled to provide oversight on anything that management does. That's, under the statute, and here I refer to this, not the new legislation, but the pre-existing statute, the board's primary role is that of providing oversight over management activities. So there is also, you do have the power to set overall policy with respect to various personnel matters.
Because I know in discussions about whether this board has any real strength or weakness, one area that people have said is that we tend not to be terrifically active in issues of compensation of senior staff. And I'm not necessarily saying we should change that at all, but it's one of the things I think that gives the board some teeth is compensation issues.
Well, you do have authority in broad terms with respect to personnel policy, including compensation. I don't think that extends to actually setting particular employees' compensation. I think that is a management function of the CEO chair, and I think that's a fairly clear division. You set the chair's salary, the CEO's salary. The CEO has the power to appoint and determine what officers and employees to hire and terminate. But the legislation, not the new legislation, but pre-existing legislation, does say among the duties of board members is to address personnel policy and manage
Not that staff here is overcompensated by any means, but I know over the course of the past year or so, people have been brought in to certain of the agencies at levels of compensation which, quite frankly, I found a little surprising. And that seems to happen just routinely without the board having any involvement or oversight on it. And that's something that I'd like to see us get a little sharper on. I know I'm being evasive about that, but...
Is it possible that there could be some type of language or just an agreement with the board that the compensation and or the increases for whether it be the chair and whomever the chair designates, that it will not exceed the agreements like in the city if there's a contract that's done and there's a 5% contract, that it will not exceed the 5% that was negotiated by other groups of people. In other words, he gets 5% next year because he got 5%, and he gets 5% the next year on a 3-year contract because he got 5%. Sort of like to structure it as opposed to saying he gets 25% and everybody else got 3%. You understand what I'm saying? It sort of like gives us some type of guideline to say you can't get more than X. You can go less if he wanted to go less to give to his employees, but he can't go more. You understand what I mean? Or
That's counterproductive myself.
Yeah,
I don't think it's counterproductive. I think it gives. I think what it does is it says to labor that, you know what, I negotiated a 4% raise, so I'm getting a 4%, but I'm now going to give Lamont 17%. That seems like.
But you might have to pay the higher salary to get Lamont.
You might have to, but then he should be able to come and say, listen, this is what I need to do.
Oh, I see what you're saying.
Getting him in at the 17%, I'm not worried about.
You mean he'd have a safe harbor if he did it within a percentage?
Right, I'm not
but,
saying bringing him in at $300,000 is my problem. That's not my problem. When it's time for him to get a raise, he can't get more than the 5% that was given to everybody else.
Unless he
Susan?
comes back to the board.
Okay, Susan?
First of all, management salaries have been frozen for 2 years. So
It's a
we
little
have a lot
academic.
different salary structure here if we were following your routine than what we have. And I want Jim to step on me if he wants to say something. There was a time, since I've been on the board, and so definitely since Jim's been on the board, where we did have discussion of salary policy. And the reason for that is that the chairman's salary and the president's salary tends to set the pattern that falls below. So the board did express opinions on, not on the individual salary or dealing with the individual numbers, but on the policy used to bring people in. In the past 3 to 4 or 5 years, when things were booming, we needed to get in good people, and the policies that we were setting precluded certain people who would have been good for the agency. And somewhere along the line, that influence and the discussions that we had disappeared. So I think what Doreen is saying, and what I agree with, and I think what Norman is saying, is that we should reevaluate that. The board should start to define what we think is a reasonable policy on setting salaries. And that has to start with you talking to us about what policies you're using, because we don't know anymore.
But just so that I'm clear, I don't want to tell him that he can't hire this guy for $400,000. That's not what I'm talking about. He can get him. That's what you want. But I know when it's time for him to get a raise, I want to be sure that he can only get X. In other words, he can't get an additional $150,000 when it's time to give out raises and everybody else got $10,000.
Well, it's got to cut
Okay,
both ways.
Jim? Okay, Jim.
I think I can safely say in the 16 years I've been here that practically speaking, the board was not actively involved in providing council oversight and evaluation and development of the compensation of senior management. I think it was done behind. We were given to it as a part of a budget, and we accepted the budget, and that was our role.
But we knew how it was being done.
That's right. It was always, but I think that in order to solve all the questions, I think the board maybe needs to be actively involved on a regular basis so that all these kind of questions don't come up. Now, how we can implement that in part of your plan, okay? Because right now, I can tell you that no 4 or 5 board members ever sat down and discussed salary policy.
Okay. So let me offer the following. I think we need to make a distinction, of course, as Jim has already pointed out, between the board's role in regard to the chief executive and the board's role in regard to overall policy. And I think we need to remember that distinction in everything that I'm saying. Obviously, there's a very clear role in regard to the chief executive as an executive decision for the board in terms of setting salary. I think the points that are being made in regard to council oversight, et cetera, as defined here, and how they're being discharged, and how they, not just how I've done it over the last 2 months, which, clearly is not a discussion we've had over the last 2 months, but how they're being discharged, how they have been discharged, and how they should be discharged is something I'm more than happy to go back and look at. I think we will, in the process of doing that, I think we need to ensure that we allow the board to achieve its role in terms of policy setting and council and oversight, and that we achieve the executive's role in terms of being able to handle the recruitment and compensation of individuals consistent with the council oversight and policy that we adopt with the board. There are many ways of doing that. There are many ways of doing compensation. I'm going to choose for the moment not to engage the specifics of any way of going about doing it, because I don't think this is the forum to engage that right now. Different ways of compensation have pros and cons in different areas. We live in an era, for example, as we know, where there are large questions that have been raised about the impacts of certain bonus types arrangements and other things like that have taken place in the financial industry, and how some of that has happened is a discussion that we might not have even had 3 years ago, but it's a discussion that certainly is a first and foremost issue that we have today. At the same time, we accept the fact that management needs to have appropriate tools in its tool chest to be able to work with its employee structure in the way of doing it. We would recognize that we have, within the 70,000 members of the company, approximately 90% of them are represented employees and go through a representative bargaining process. Approximately 10% of them are non-represented employees. I would finally also underscore a point that has been made, just so there is no misunderstanding about that at the table or publicly. The managers of the company have not had raises. And that is a situation that has now occurred, I believe, for 2 years running. It has been a reflection of the way that the management of the company has dealt with the significant financial issues that the company was facing. But I don't want there, because I think this is important to recognize, I don't want there to be a misunderstanding that the managers of the company have had raises in doing that. But I will certainly come back to the board and find an appropriate way to be able to do that, to be able to discuss this. Okay? With that understood, and recognizing that these are guidelines as opposed to the specific policy actions, et cetera, but these are intended to be the guidelines of what the board will do, can I ask for a motion on the revised governance guidelines as they've been presented?
Second.
In favor?
Aye.
Okay. Thank you. Now, there's a second part to this, which we should let Jim go through, which is the labor governance guidelines. And this is a response that we have tried to make to some of the views that were expressed about confusion about the roles and various roles in regard to the labor contracts and the situations that we find. Right?
Thank you. Yes. In addition to reviewing the governance guidelines, I was asked by Chairman Walder to work with our Director of Labor Relations to look at principles that might be articulated to address governance.
Do you want to come up as well?
Of the labor relations matters for consideration by the board. The proposed draft guidelines that we developed for governance of labor matters are set forth in your book beginning on page 133. It's a relatively short document, about 4 or 5 pages. I will give a quick overview, but it's in the book and for your reading. The purpose, I thought it might make sense to try and think about what's the purpose of, if we're going to have such guidelines. They start off by setting forth a purpose, which is to summarize, to make sure the board is kept apprised of significant developments affecting labor relations and collective bargaining, and to enable the board to engage in meaningful oversight of MTA management with respect to labor matters. I think there was a lot of discussion in recent months about the importance of that, and the purpose of the guidelines is to address that and provide ways of securing it. By way of background, historically, MTA, as far as I have been able to learn, has not had any written guidelines to define board and management roles in labor matters. However, the lack of written guidelines traditionally, as I understand it, and my time here is short, has not meant that the board was uninvolved or left uninformed on labor matters. The board, to the contrary, the board, as I understand it, traditionally has been briefed by management as to significant labor developments, allowing it to perform its oversight of management conduct of labor relations, and has consistently been presented with labor agreements for ratification. So I think there's a tradition here of doing those things, but it hasn't been reflected in governance guidelines. The step we're doing in drafting guidelines is to seek to protect and preserve that traditional board oversight role and the contract ratification role, while allowing the executive to perform its traditional role, which has been of exercising the responsibility for directly leading and managing labor relations. So the proposal set forth in the governance book may not contain all the answers, but it tries to provide the general ground rules to govern the board role and the CEO role. On the next slide, the governance guidelines. So the governance guidelines have a purpose. They also set forth in a very the basic responsibilities as I've mentioned them. The CEO, as you know, is generally responsible for executive responsibilities and administration. As such, he's also responsible for management of labor relations at the MTA agencies. The board responsibility, consistent with the statutory role of oversight, is to oversee the management in the conduct of those labor relations, and also it has had the role of making a decision whether to ratify collective bargaining agreements that are brought forward to it for its consideration. So those, as I understand it, have been the historical and also are statutorily the roles of the CEO and of the board.
Do we want to hold questions till the end? Or
I
is
think
this
it's
the
helpful
end?
for Jim. I think you're going to continue.
Yeah, I have a
Let
little bit
him
more.
continue
I don't have a
then.
lot more because I'm just summarizing the guidelines. If I get the next slide. So we've set forth the purpose. We set forth what we thought the core rules were, and then in the governance guidelines on labor matters, we tried to set forth to enumerate responsibilities that management or commitments that management would have to the board in terms of so that the board could fulfill its core responsibilities. And the first principle of responsibility is that the chairman, CEO, will be accepts the role of being the principal liaison with the board, it'll serve as the liaison between management and the board, and working with the MTA Director of Labor Relations, be responsible for providing the board with information regarding labor matters that are relevant to the specific decisions that the board is required to make and to the board's effective fulfillment of its oversight responsibility. Second, and a lot of these are closely related, the chairman would, under the guidelines, assure members that they will receive regular briefings on significant labor developments. You can't do your oversight role if you don't know what significant events are occurring. The briefings would customarily be made by the Director of Labor Relations. We've tried to put some flesh on what significant developments means, and the slide after this addresses that, but that's, an important part of this is that you get briefed on significant matters. The third principle of responsibility is that labor contracts come to you for ratification. The board has to determine whether to ratify the contract or not. And the idea is that those briefings would occur when time permits, also at the committee level of the affected property and at finance. We all recognize there are occasions when, in labor matters, when the timing of a negotiation or something can make that difficult and can make it necessary to go directly to the full board, but the commitment is to make every effort to try and go get the committees briefed in advance of the full board briefing. The fourth principle of responsibility is that the Director of Labor Relations will work with the agency presidents to ensure that you're furnished with information pertinent to labor matters that are scheduled to come before the board, and if there are something that the Director of Labor Relations or an agency president knows that they think ought to be coming to the board but isn't on the agenda, that they will bring that to the chair's attention so that it can be put on the agenda. And the fifth principle of responsibility that we put in the guidelines was that really it has to do with the organizational responsibilities within the executive. Collective bargaining matters are going to be managed and under these principles by headquarters through the chair, CEO, and the Director of Labor Relations, and agency presidents, consistent with their role as general managers of their organizations, would be responsible for day-to-day matters affecting labor relations. So those are the principles that we set forth in the guidelines. They're intended to further the ability of the board to fulfill its responsibilities. The next slide, I mentioned that since one of the principles is providing briefings on significant developments, we made some effort to put some flesh on that. This is a non-exclusive list. It's not meant to be, there could be other significant developments, but we tried to identify at least some of the core areas that would be expected for briefing. But there certainly are other things that could be significant upon which you should be briefed too. So that's what we put together. We put it out there, and I hope that it's helpful in addressing the concerns and in furthering, the objectives and purposes of the board here.
So my intent, as I said, was to try to be responsive to the board, given the discussions that we've had, and to bring some clarity to an area that seems to have fallen, for whatever reason, into a lack of clarity about the way that it is to be handled. This is effectively describing both the CEO's role and what one believes the CEO has as a role in doing this, and obviously the board's role in terms of the oversight of that. And those are intertwined efforts, but intertwined in a way that delineates a management executive responsibility and an oversight and ratification responsibility, which sits with the board as contained, as Jim said, as contained in statute. Open for discussion. Doreen, you had a question that I wanted to come back to.
Yes, a question, because I'm a little cloudy on how this works, but first a compliment. I think you took a lot of our frustrations and I think modeled something that makes me a tremendous amount more comfortable, so that hopefully what has happened in the past will not happen again, in terms of all of us not feeling that we were terribly in the loop about what was going on.
Well, I hope it is responsive, and it was certainly a joint effort with the chairman and our Director of Labor Relations.
Well, thanks to all of you who worked on this. When two parties decide to go to arbitration, or if one party calls for an arbitration, is it automatic therefore, the board could be informed of it, but basically it's too bad. This is what's happening. Is that a fair characterization, or is that inaccurate? Because I think all of us felt, gee, we didn't even know we were going to arbitration, and then
I'm going to defer to Ben, although I'll quickly say, under the public interest arbitration, the Taylor Law provisions that govern public interest arbitration, they provide for arbitration of certain of our contracts when there's impasse, and that a party who believes that impasse can petition the board, and the board makes a determination whether there's impasse, in which case it's mandatory, or the parties can stipulate that they're impasse.
okay,
The board is authorized the public insurance.
right.
There's mandatory arbitration.
Microphone.
Microphone.
But it's not mandatory that the parties agree to arbitration prior to an impasse finding by the mediator and the board. So that it is, if that's the pleasure of the board and the chairman, possible that prior to agreement to arbitration, the sense of the board could be obtained.
It's actually, I think, to be clear, on page 135, specifically notes that one of the areas at which the chairman and CEO has a responsibility to have regular communication with the board is proposed agreement to interest arbitration.
The wording on your slide is a little different than the
What
wording
is
in the
interest
book.
arbitration?
Interest arbitration, I'm sorry. Interest arbitration is where, rather than a negotiated settlement, a third-party panel, in this case, imposes a contract, determines the substance of what could have been an agreement. It is as if the court made a decision as opposed to the parties agreeing upon a decision.
Are you taking typos, by the way?
Sure.
I'll get
Maybe
into the
later.
meeting. My last question was having to do with the role of the agency president. I would hope that on work rules, Tom Prendergast would be very, very much in the loop about all of that, and it wouldn't just be the Director of Labor Relations, because I don't think anybody knows more about work rules than an agency president. So how does that relationship work? Because I think there were some issues with that the last time around.
That's the normal course should be, in my opinion, that in fact labor relations' job is to get what operations needs, consistent with the financial jacket that we're in. And in order to do that, it needs to take instruction from the people that know operations best. And that would be, and that's how it's normally conducted. What is not normally conducted is that there are parallel negotiations going on.
There can only be one party negotiating.
Absolutely.
It would be the simple way in which I would express that. Susan?
Okay.
I need a clarification of one of the phrases, and then I may have a comment about it, but maybe not. It's the third one. It's the third one down. What exactly does that mean? Status of negotiations with respect and impactful CBA, including the
respect
parties.
to.
We're missing the two. That
Missing
was
the word
typo.
"to," yeah.
Oh, yeah, I'm sorry. We should be respect to an impactful CBA. Impactful, I think, is a term meant to, we have a lot of collective bargaining agreements because there's some very small ones, there's some very large ones, those that are of, financial significance.
We have a contract with 2 photographers. It's probably not impactful. On the other hand, there are major agreements with the railroads coming up. So we're talking about things that are significant that we believe you would want to know.
Which would include both sides' positions.
Yes, the declared positions, I think the board would want to know, and if you don't want to know, I'm sure you'd tell me. There is a certain amount of bargaining that has to occur off stage,
Sure.
but that doesn't mean that we can't state the declared positions of the parties.
2 comments. The first is I I'm a little concerned about the timeliness of information, because I found that to be a bit of an issue in the past. So the first of the chairman's responsibilities, I think, needs to have the concept of, we need to know about it before it's too late for us to have an opinion. So a timeliness issue. I like your wording for the fourth block down on the slide much better than the just proposed agreement to interest arbitration in the book. And my last comment is, in the third one, where you're presenting key issues to relevant board operating committees, because our contracts, and even the city contracts, tend to be used as a pattern to move ahead, it's more than, to me, it's more than just relevant operating committees. I think it's very difficult to come to any agreement throughout the agency without some information to all of the agencies, because it sets precedents which flow to the other agencies. So I don't know that that's feasible to do, but I just want to make the point that sometimes I think it helps to know what other agencies are doing.
I think excuse me. I think the intention is that finance be
Will do
briefed,
that.
and hopefully that will perform some of that knitting
Together.
function that you're referring to. I think it would be difficult to, really impossible to brief every operating committee.
No, I agree. As
But
long as-
that is the role of the Finance Committee in this,
Okay.
and I think, again, if I speak for myself about the intent, I thought it was important that this not just be the Finance Committee, because you could make an argument that this is just the Finance Committee, right?
Well, that speaks to you.
and I felt it was important that we establish the principle of this discussion being both with the Operating Committee and with the Finance Committee. As Jim or Ben pointed out, there are, of course, some times when that's impractical given the schedule of something going on, and we'll have to deal with that as the case is. But I think we need to establish the appropriate principle in doing that. I think I would also suggest, if I can suggest a wording change to accommodate Susan's well-placed point, that the members of the board shall receive regular and timely briefings, would I think address her point.
Thank you, sir.
So, and that was implicit, but let's make it explicit. I wasn't trying to do anything other than that.
I only have one question, and that is,
I'm sorry, Norman, I'll get you there. I missed you. I'm sorry.
there's a place in there where the board ratifies the, my question is by the ratification, does that also serve as a budget amendment? In other words, my point is, if the agreement is outside the window that this board has taken, okay, by ratification, does that mean that we ratify that amendment? If not, then how does that amendment get to us through finance?
Yeah, so, I mean, the ratification is of the labor agreement. The implications of the labor agreement in regard to our financial position should have been discussed as part of the discussion that takes place. No question about that, right?
Mm-hmm.
So if we have a plan that allows for X and we have an agreement that's Y, the difference between X and Y, positive or negative, should be part of what has been the discussion in doing it.
Mm-hmm.
The actions in regard to the financial plan would be dealt with in the financial plan process and in the budgeting process. That may or may not be, the actions may or may not be done through the normal course of events, so because we come back to the board periodically to be able to do that anyway, or it may require other actions that would take place, which I would expect would go through our normal process of engaging both the operating committee and the finance committee before going to the board of directors. So, I mean, but it would not be, but there is a separate process. It doesn't automatically amend it in doing that. Norman, I'm sorry.
Yeah, don't be. The probably 28 or 30% of the employees, MTA bargaining unit employees, are Railway Labor Act employees. They're not Taylor Law employees. And of the last 3 collective bargaining agreements, 2 have gone to presidential emergency boards, and one of them actually resulted in a strike. Last round, we went to Presidential Emergency Board. We're released to strike. However, we resolved our issues, thankfully, before the drop-dead date. But as you guys are aware of, the the prevailing paradigm in private sector collective bargaining pertains to a large degree to Railway Labor Act negotiations, in that drop-dead dates and clocks ticking matter a whole lot. And then there's an additional issue with that. I mean, I imagine a scenario, and I'd kind of like a clarification from you how you envision board input working out in that sort of environment, where the clock is ticking and we're trying to make a deal before midnight, maybe extending the clock a couple hours into the wee hours in order to make an agreement. And then ratification process, or I would even say ratification jurisdiction, I think is somewhat, it occurs to me, is somewhat problematic when you have a presidential emergency board created by Congress to resolve disputes. That's what the Railway Labor Act does. Now, I recognize that you have a long-standing legislative agenda. I might point out a long-standing failed legislative agenda to take us out of the Railway Labor Act. It's actually a Supreme Court case supporting our position. And I suggest reasonable people could conclude you're not going to be able to take us out of the Railway Labor Act.
Failed for the last 30 years or so. I don't think you should grow.
Well, I never give up. I never give up myself. But in any event, do you feel that the board could conceivably fail to ratify an agreement to which the National Mediation Board and both parties at the table had agreed? And knowing that, I mean, as the clock is ticking and going down, is the guy on the other side of the table in the Railway Labor Act environment, is he able to make an agreement? Or do you feel that even in that environment, like I said, with the Presidential Emergency Board created by Congress, with Ben Fernandez shaking hands with us on the other side of the table, do you still feel you have a right to, clearly you have an obligation to review the elements of the agreement.
So, you want to answer it? I think it goes without saying, Norman, I think it's what you're partly driving at, is that the union negotiator as well as management has to have confidence that if they make a deal, it is a deal. And I think the way that's best accomplished is through informing the board and the negotiator understanding what is acceptable basically and what it would be repugnant to the board, so that the negotiator knows the limits of his or her authority and therefore goes to the table with the union, and when the union agrees, it is in effect a deal. And it's not going to be second-guessed because the board already knows, has given instruction, what is the parameter, what are the possibilities? So the negotiator knows his level of authority.
Well, if you humor me just a little bit further, I mean, it could be even more extreme because people could actually be on strike at some point. And
yeah.
then it really becomes an issue of be careful what you ask for as far as a board, because you'll have to be there. I mean, I don't like being in that position myself. It's like someone's, stuck you in the stomach with a knife, you guys that have been there before. And it's not a very comfortable position to be in. And I suggest the board is not really well equipped to handle that sort of thing. Labor relations professionals like Ben are much more accustomed to, holding the gun to each other's head.
It's also possible your membership might turn down a deal. So when you say
exactly
a deal is
right.
a deal, it doesn't mean that it's certain. It means high probability.
Mm-hmm. Right.
But I think
well, that's the whole thing with me too. Is that it involves a commitment from my side to do everything you possibly can to get an agreement through. And I think that what you're saying to me is that you maybe the language in here includes something that presents the consequences of saying no to an agreement. I mean, with the members, if it's a strike situation, the consequences of saying a no is you're going to have to go without money.
Let me, because I think Susan's comment actually is very relevant here. We've inserted the word regular and timely. And timely has a meaning that is contextually relevant. And I think your point, as you are raising this, Norman, is that timely may well involve many discussions in a short period of time to be timely. It may involve few discussions in a longer period of time to be timely. It depends on the circumstance and where we are in doing it. I think the point Ben is making is it's the responsibility of the chief executive to work with the board to understand the sense of the board and the parameters under which this is going forth. It doesn't take away the board's obligation or right to ratify, but it is incumbent upon the chief executive to have a sense of the board, and to the extent that negotiations move into a place different than has been previously discussed, then I think the word timely again would say that that is the cause for further discussion with the board. So I think your change actually is quite helpful in regard to the point that Norman is raising as well. But both sides in any process have the ratification process following the negotiation, but it is incumbent upon us to handle it in a way that is consistent with the discussions we've had with the board.
Let me ask you one more that may display a little bit of my ignorance of the legal process. When you say regular in these terms, the terms that are used in the Railway Labor Act are emergency boards and those sort of things. And the word emergency, I have a very clear understanding in certain respects of what a legal emergency constitutes, meaning unforeseen circumstances. On the other hand, is there sort of a force majeure consideration here that in the event you're in a federal emergency strike, by definition of federal law, that the board would be, if you made a deal, it would not really be, this is not regular business. This is not, where Taylor law has a process that holds both parties strictly through into a PERB.
No, communications with the board and the chairman, they can happen real time. There's no force majeure where the negotiator has to be able to make a decision without knowing what the sense of the board is. That can happen simultaneously. I understand it's not a process that's delayed, and when a strike is looming, the likeliest chance to make a deal is when tension is the highest, everyone wants the tension relieved, and that's when the deal can be struck. But there can be real-time communication with the chairman.
It's long. Not holding the negotiations in a subway station, because we don't have real-time communications there.
I warned you I would display my ignorance.
Norman.
I think that being briefed with labor negotiations is a good thing. But to my colleagues, I think that we should stay out of certain parts of labor negotiations, 100% out of. We need to give the authority, complete authority, to the CEO to do what they have to do. I know labor negotiations inside and out. And what Norman is raising is a very, very critical point of saying, if he has to bring that to the board and that time lapse and something goes wrong because we couldn't get together or we couldn't make a decision, that's not a good thing. I would suggest, and you've done great work on this stuff, but I would suggest that we give the power to the chair to do what it is that they have to do and brief us before an arbitration and get our opinion, or brief us before something really significant. All of these minor things here that I'm looking at, it's really not good because we're going into a really, really dangerous area with labor negotiations, a very, very dangerous area. Now, me personally, I would have to ask that this part of it be tabled, redone, so that the power goes to where it belongs, as opposed to us being able to, well, let's sit down and discuss this. No. That should be strictly for labor relations, the CEO, and you come and brief us. I'm cool with being briefed. I'm cool with saying let's not go to arbitration. I'm cool with certain things like that. but I am certainly not cool with sitting down saying, okay, we're in the 11th hour. We got 21 minutes to make this decision. It's 10 minutes before the clock ends. This policy and procedure that's here says it's got to come before us.
No,
I want to be absolutely clear, it does not say that.
Okay,
It says
then I'm
there should be
reading it wrong.
Okay, it says there should be regular and timely communication, but it does not say that that's the process that's here, and it's carefully worded not to do that, because I think that's impractical and runs against what are the roles of the chief executive as articulated in here as well.
What's regular and timely then? I mean, for example, I'm just playing devil's advocate here. For example, tomorrow morning, you know, you guys are in negotiations, everything's going well. We didn't get briefed, nobody got briefed. We find out later on that, you know, a deal is done, whatever. Somebody raised their hand and said, wait a minute, I wasn't briefed on that. Where's the guideline that says, you know, I'm not trying to be a smart ass here. I'm trying to get out of that loop, of that particular loop of labor relations. I'm trying to get out of that one.
I want to respond, because my initial reaction was like yours. And it's only by listening to Ben that I've come to feel very comfortable with this, because I have confidence that when you come and give us the story about what kind of negotiation you're in, the board will be able to say, you go here, we can't deal with it. We like this. And I'm confident, because these things tend to go for quite a long time, and then they get tense at the end. But every time I've seen you go through this, when you were in the negotiation, you knew whether it was going south or whether it was going the way you thought it should. That's the kind of timely I want. When it comes down to that 11th hour, if we haven't expressed, as a board, if we haven't expressed what's acceptable to us by the time you get there, then we haven't done our job. Because he can't be calling us in the last 10 minutes. Absolutely not. He can't be calling us in the last day. We've got to have enough information to know before that. And we have to provide enough information to him. It's a two-way street. And if we're not doing our job, then he can't do his.
Jim?
Well, I think based upon what I read and what I see here, I think that it makes me comfortable, because I think what this says is that our chairman has to keep us informed and keep us up to date, so that when he's sitting there at that last minute, he knows what the sense of the board is, and he's going to make a decision, period. Well, this is not something that he's going to talk to us the day before about and say, oh, tomorrow this is what we got to do. I think this is a process that we keep on a timely basis, the things that are coming up that you may find important, to get a sense of where we stand, so that when you're sitting there at that last minute, that discussion has already taken place in some way over the prior 6 months or 2 months.
Or 2 days,
Or 2 days.
if, as Norman points out, things move at a point.
Exactly.
The point here is that there, at least again as I've seen it, the point is that having discussion, having a sense of the board informs the process that we do for negotiation. We don't want to put the role of the board in the middle of the negotiation. And I think and I think both Normans, both of whom are experienced in the labor process, seem in their own way to be seeking that clarification. And I think that's the clarification that's being given at the table. But at the same time, I was trying, working with Ben and Jim, to be able to articulate that it is the responsibility of the chief executive to ensure that there is a regular dialogue and communication with the board. And I do recognize a sensitivity around some view that communication did not take place as appropriate. And I'd like to make sure that communication does take place. So that's the line that I think we're walking right here in doing it. I guess the question is whether we are satisfied that the words that are here convey that, right? Because I think everybody is saying effectively the same thing. I don't sense a difference of opinion. I think the question is whether we're satisfied that the words say that.
Yes, I think they do, yeah.
I think you do.
And we don't have the right to, we don't have a ratification right anyway. It's up to you. If you sign a contract, that's the contract. We can try to remove you. or complain.
Actually, no. You do have a ratification right. And no, you can't remove me, but you do have a ratification right.
If you sign a contract, it's a contract, isn't it?
It's signed subject to ratification.
It's done subject to ratification.
Okay, well.
It's subject to ratification.
So that's the issue then, that he's raising is the issue.
Yeah, but Norman accepts it as subject to
Yeah.
ratification.
No, I agree.
He wants it to be clear that, I mean, again, I don't mean to speak for you. I don't think there's a misunderstanding that it's subject to ratification.
Okay.
I mean,
Okay.
both sides are subject to ratification. That's
Yeah,
a normal
right.
labor
Yeah,
process.
that's normal, right.
Right? The issue is to ensure that the people who are bargaining have both a sense of the board in terms
Right.
of where the board is, but also the ability in a constrained time environment, which most of our bargaining ends up being in the end of the day, in a constrained time environment, to be able to make a responsible decision with a confidence about what is going to happen. And that's I think both sides, whether it's the union side or the management side, need to be able to make decisions with a confidence about what would ultimately happen. Doesn't help anyone to be in a process in which agreements are not ratified by either the membership or by the board. I don't think either side is helped by that. Okay, so can I ask for a motion then?
Motion made.
Second?
Second.
Okay, in favor?
Can I abstain? I abstain.
Okay.
Okay.
We have now failed in my task to have this complete by 1 o'clock, and I have a meeting with that I need to get to quickly. So is there other things that we need to do, and can we do them quickly?
Well, the next item on the agenda, if I can get this slide, is the bylaws update. This is not too hard a one, given the discussion we had of the governance guidelines previously, because we review the bylaws to make sure that they are conform to what our practices are and conform to the law. For the very same reasons that we revise governance guidelines, we have gone through the bylaws and made revisions to the bylaws to have them conform principally to the May legislation, which made these changes in the structure, as well as to fix or address ambiguities here and there to conform in the language when we have a clear practice about how we do things, and it's the way we've done it, but the language.
The guidelines are on page 138. Can I have a motion, please?
Motion made.
This is the bylaws.
I mean, the bylaws are on page 138. Can I have a motion, please?
Motion.
Second?
Second.
Agreed?
Aye.
Okay. Next are the committee charters.
It's been passed all day.
They've all been reviewed by the committees, right?
The charters, yes, each committee is required to review the charters,
Okay.
and they have been reviewed by each committee. So as we put them together as a group to take to the board, but you have seen them in the changes that you are reflected here.
So in favor?
I have a suggestion.
Sure.
Governance Committee, charter. It says 11 members, and we've never had 11 members, so maybe we should do something that's more realistic.
3.
The others are 3.
Yeah.
There's 11 members on the government committee.
3 or more.
Page
Yeah.
189.
Right.
Thank you.
All right, may I suggest then that since this is the governance committee, that an appropriate revision be made there.
Right, we can do that now.
Okay.
At this point. What would that?
I think
So
we take
consistent
any
with the other would be 3 or more, is
3
that
or
correct?
more, yeah.
Okay, so can I call for a vote on the guidelines in general with an amendment to the Corporate Governance Committee guideline to amend
the
this?
charters.
Charters.
Charter.
To say 3 or more and amend that section for presentation to the board. Do I have a motion?
Motion.
Second?
Second.
In favor?
Aye.
Okay. I think that concludes our
Vote on this one.
business. Is that correct?
Change, right?
Can I have a motion to adjourn?
We got to vote on this one. Right?
Well, we
You've
accept,
changed it, we accept it
and
with
we-
the change.
Yeah,
and
we
we're
accepted
voting
with the
at
change, so
same time.
you did
Okay.
it. We went for
And
two
your-
for.
And the board moved to recommend all the charter changes for other committees to the
Right.
full board.
Yes.
Right.
There were two additional items that I don't think we have time to go over now. One was Lamont making a brief presentation in compliance with the procurement lobbying law. We do have existing lobbying law policies as required.
Right.
The agencies have adopted policies. We
And
do
there have been no
implement them.
violations.
And there's also a government, the board self-assessment is going to be distributed in January. If there are comments that people have,
You should get
committee
the-
chairs,
right.
they should communicate them to Lamont.
It will go out on around January 10th.
Can we-
That's a draft. That's a draft.
Comment on the way
Thank you.
yours is
Okay.
set up. We get them.
You were technically out of sequence, Mr. Hendley.
And we're going to be getting revised copies of all of this, so we can, all the ethics guidelines, so I could update.
You'll get clean ones.
We'll get a new
There are
book,
clean
right?
ones in there, but, yeah, when they're adopted.